distinguished guests all. Welcome to the Selden Society Australian Chapter lecture to be given by the Honourable Justice Margaret McMurdo AC on Justice Sandra Day O'Connor. I welcome also those present virtually in the courthouse in Townsville. The Honourable Justice Margaret McMurdo AC graduated Bachelor of Laws from the University of Queensland in 1976 and served as clerk and then associate to Judge Demack in the District Court and the Family Court of Australia in 1975 to 1976. She was admitted as a barrister of the Supreme Court of Queensland in December 1976 and worked in the Public Defender's Office from 1976 to 1989, holding the office of Assistant Public Defender 1978 to 1989. She practiced at the private bar in Brisbane from 1989 to 1991, holding a commission to prosecute. Her honours roles include being the first woman to be appointed to the District Court of Queensland, that was in January 1991, the first woman appointed as the presiding judge of an Australian appellate court, being the second president of the Queensland Court of Appeal, appointed in July 1998, and a founding committee member and president of the Women Lawyers Association. Justice McMurdo was awarded the Centenary Medal in 2003 and received the Queensland Law Society's Agnes McWhinney Award in 2006. She was appointed a Companion of the Order of Australia in 2007 and holds honorary doctorates from Griffith University 2000, Queensland University of Technology 2009 and the University of Queensland 2012. Looking around, I can see that most of you don't really need any introduction such as I've given, but I remind you all that this lecture will be on YouTube, where others will also be looking at it, no doubt. I ask you to welcome our speaker.
Thank you, Hugh. I acknowledge the traditional owners of this land once known as Meanjin, the Turrbal people, and across the river, the Jagera. I pay my respect to their elders, past and present. Your Honours, members of the Selden Society, ladies and gentlemen, it is my great pleasure this evening to share with you something of the remarkable story of Sandra Day O'Connor, the first woman to be appointed an Associate Justice of the US Supreme Court, or FWATSIC, First Woman on the Supreme Court, the acronym she gave herself. First, I will speak of her life before the US Supreme Court, her formative ranch upbringing, the challenges for a young woman lawyer with children in the 1950s and 60s, her grounding in Arizona Republican politics, and the lead-up to her appointment. Second, I will speak of her work as an Associate Justice in the US Supreme Court, although in this 50-minute address, I can give but a small slice of the very large O'Connor jurisprudential pie. I will focus on her opinions concerning Roe and Wade and the ever-topical issue of abortion. I will finish with an insight into this remarkable woman's public contribution since she resigned from the court. For those of you who are not lawyers or judges, it is important to understand that, unlike in Australia, England or New Zealand, US judges are usually closely aligned to the politics of the government that appointed them, with many judges actually elected on a Republican or Democrat ticket. I emphasise that Australian judges, once appointed, do not have party political affiliations and are not expected to make judicial decisions according to the political view of the government which appointed them. I fear this is something not understood these days by some Australian politicians. And even in the US, the principle of judicial independence and the doctrine of the separation of powers means that judges, at least those who are appointed, not elected, cannot be expected to deliver opinions that accord with the view of the government that appointed them. Sandra was the first child born to Harry and Ada Mae Day in 1930 in El Paso, Texas, just as the Great Depression hit. Harry had planned to attend Stanford University, but the First World War and his father's ill health led him to take on the management of the family's marginal cattle ranch, the Lazy Bee, named after its cattle brand, a bee lying down. On the border between Arizona and New Mexico, the Lazy Bee was anything but a honeymoon cottage, yet this was where Harry brought his attractive and refined new wife. There was no running water or electricity, but Ada May, who had grown up in comfortable circumstances, managed to cook for both the family and the cowboys, wash clothes and linen using a corrugated washboard, and was always impeccably dressed. The locals enjoyed seeing her fashionable outfits when she came to town for the weekly grocery shop. It was the closest many of them came to seeing a stylish, well-dressed woman. The cowboys taught the Day children that only the toughest survive. Their mother taught them that kindness and love can also produce survivors and in a happy atmosphere. From those earliest years, Sandra learned both courage and compassion. At the tender age of 6, she went to live with her maternal grandmother in El Paso to attend school. She missed ranch life and was desperately homesick, but she knew she had to be brave like the cowboys. When reflecting on her youth as an adult, she always focused on the romantic ideal of her ranch upbringing, even though she spent most of her childhood in El Paso, where she attended a number of schools, including the Radford School for Girls and Austin High. Her sister Anne was not born until Sandra was 9 years old. Their brother Alan came along 18 months later. There was no room for self-pity or wallowing in the Day household. There was a job to be done, it was done, no excuses accepted. In her memoir, Lazy Bee, co-written with Alan, Sandra recounts an exceptionally hot day in the middle of the 1945 Arizona summer. She was 15 years old and home for the holidays. Her father and the cowboys were out branding cattle. She and her mother had prepared their lunch, and she was to deliver it by driving an old truck a considerable distance over rough terrain. She was far from the ranch house when the truck became wobbly and heavy. The left tyre was flat as a pancake, and she was the only one around. Luckily, there was a jack and a spare tyre. She put rocks behind the other 3 tyres to stop the truck rolling and jacked it up. But the lug nuts were rusted and wouldn't move. She jacked the truck back down and managed to loosen the nuts by stomping her foot on the lug winch, finally cracking them loose. She jacked the truck up again and finished the job. Feeling pretty chuffed for a 15-year-old, she arrived with lunch 1 hour late, but with good reason. She expected paternal praise for her initiative and resourcefulness. Instead, her father ignored her. When he finally spoke, he said, "You're late." When she explained her misadventures, he gruffly responded, "You should have started earlier. You need to expect anything out here." An obstacle was not an excuse, and overcoming it was not an accomplishment. Harry Day didn't touch the lunch his adoring 15-year-old daughter had so carefully prepared and taken so much trouble to deliver. He was, however, a kind man, revered by his children. He was also a perfectionist who never admitted to being wrong. Harry was pleased to live out his thwarted academic hopes through Sandra when in 1946 she enrolled at Stanford University. She completed a BA in economics in a mere 2 years. Her classmates remembered a popular co-ed with fashionable clothes and a friendly nature who made everyone feel at ease and who was adept at disguising her considerable intelligence. And to prove what a shrinking world we live in, Justice Peter Applegarth tells me his next-door neighbour was at Stanford with Sandra Day. As Sandra enjoyed a law class in her undergraduate degree, she successfully applied to the law school, becoming one of only 5 women in the class. She went to the movies on a few dates with another law student, Bill Rehnquist. Little did they think, serving together on the Standard Law Review, where Bill was the presiding editor-in-chief, that decades later they would serve together on the US Supreme Court, Bill again presiding, this time as Chief Justice. Bill was no competitor in the boyfriend stakes for another student working on the Stanford Law Review, John J. O'Connor III. The debonair John suggested he and Sandra complete an article over a beer at the pub. This led to a date the next night and the 39 nights after that. As their relationship became serious, Sandra took John, a San Francisco city slicker unaccustomed to ranch life, to visit the Lazy Bee. When they arrived, Harry was branding cattle, while the cowboys castrated steers and earmarked calves. Harry reached into a dirty-looking bucket and pulled out a couple of bloody testicles, trimmed the mountain oysters, as they were known in Arizona, and put them on a baling wire and placed them over the branding fire. He handed the skewer to John, directing him to eat. Like Sandra, John was not short of courage. He ate up, winning Harry's respect and Sandra's heart. It was a most memorable welcome to the Lazy Bee. As graduation approached, Sandra, who had an excellent degree, called each of the 40 firms that advertised vacant positions on the Stanford notice board. None would hire a woman. By contrast, Bill Rehnquist had begun a prestigious Supreme Court clerkship with Justice Robert Jackson. Although Sandra was only 1 or 2 places behind Bill, it was unthinkable in 1952 for a male Supreme Court justice to have a female clerk. Sandra circumnavigated that obstacle by asking her girlfriend's father, who worked in the large law firm Gibson, Dunn and Crutcher, to meet with her. He said she had an outstanding resume, but could not see his firm hiring women lawyers. Clients wouldn't stand for it. Instead, he offered her a job as a legal secretary, which she politely refused. She surmounted that obstacle by writing to the San Mateo County attorney, who was considered a revolutionary as he hired women lawyers. He was very impressed, but didn't have funding for another deputy county attorney. Sandra overcame this obstacle by immediately offering to work without a salary. There was yet another problem: no vacant office. She overcame that obstacle by working from a temporary desk in the secretary's area. She had neither salary nor office, but she had her first job as a lawyer. Her enthusiasm paid off. 4 months later, when the county attorney was appointed to the bench, Sandra became a deputy county attorney. Like so many trailblazing women in the law at this time, her career began in the public sector. Life was exciting. She loved her legal work, and she and John married at the Lazy Bee in December 1952. The following year, John was drafted into the army during the Korean War, and they moved to Frankfurt for 4 years. John worked in the Judge Advocate General Corps, and Sandra was a civilian attorney for the United States Quartermaster Corps. When John left the army, they decided to stay in Europe to ski until the money or the snow ran out. After 3 months, with both the money and the snow gone, the O'Connors came home to settle in Phoenix, Arizona. They each passed the bar exam in the summer of 1957. 3 days after they were admitted to the Arizona bar, their first son, Scott, was born. Sandra found a babysitter and went job hunting, but law firms were still not hiring women. She overcame that obstacle in the following spring when she and Tom Tobin, who met while studying for the bar, set up their own firm. With second son Brian's birth in 1960 and her babysitter moving away, she left paid employment for about 5 years. But she was not your regular stay-at-home 1960s all-American mom. She had developed an interest in Republican politics, eventually becoming county vice chairman of the Republican Party and also president of its all-female Phoenix Junior League, a voluntary community service organisation. She was influential in both the male-dominated mainstream party and the party's women's group. A third son, Jay, was born in 1962. In 1965, she returned to paid employment as an Assistant State Attorney General, the first woman in that office. She wanted to work part-time, not to spend more time at home, but because her role as president of the Junior League was time-consuming. But part-time work was not then an option. She overcame that obstacle by making herself indispensable in her legal role. Her employer then agreed she could work on her terms, including part-time. In 1969, a vacancy arose in the Arizona State Senate. She was encouraged to stand, was selected as a Republican candidate, and was successful in the next Senate election. Senator O'Connor was made chair of the State, County and Municipal Affairs Committee and a member of the Appropriations and Judiciary Committees. In a 1970 speech to women students at Arizona State University, Senator O'Connor joked, "One advantage to being a woman in politics is that while it's not too difficult to put your foot in your mouth in politics, it's a lot harder to do when you're wearing high heels. She also quoted anthropologist Margaret Mead, "If women want real power and change, they must run for public office and use the vote more intelligently." She took Mead's advice and in 1972 ran for and won the role of Majority Leader of the Arizona Senate, the first woman to hold such a position in the United States. During her time in the Arizona Senate, she effectively lobbied for the repeal of several gender discriminatory laws, including a bill that repealed a law preventing women from working more than 8 hours a day. She argued, "These laws were originally designed to protect women. Today, they tend to discriminate against them and to cause them economic harm because they make employers unwilling to hire women when the job might, on some occasions, require overtime." She led the revision of laws governing community property to give women rights of management over marital property and sponsored the removal of male-only language in legislation. She is remembered by her colleagues for her devotion to detail, once introducing an amendment to insert a comma into a bill, as she felt this clarified the meaning of the new legislation. She became skilled at building consensus to pass legislation through understanding her fellow politicians, tactfully reframing issues, and being firm when necessary. Family life remained her bedrock. Even while leading the majority of the Arizona Senate, she cooked dinner for her family every night. Husband John joked, "I think it's a tribute to American democracy when a cook who moonlights as a janitor can be elected to high public office." In the 1970s, when feminists were considered radical and frightened the Republican conservative wing, Senator O'Connor, a successful, high-achieving woman lawyer and politician, managed not to seem threatening. She was an attractive blonde wife and mother with traditional feminine country charm and excellent Republican credentials, who often reassured her audience that she had come with her bra and her wedding ring. In 1974, after 2 terms, she announced she would not seek re-election as a senator. 1 month later, she announced her candidacy for a new Superior Court judgeship in Maricopa County, an elected position in a tightly contested primary. Her legal credentials were questioned by her Republican opponent. "No judge I know ever remembers seeing Mrs. O'Connor in the courthouse." In her defence, she said, "There are lots of lawyers who can go in and fill the functions of a judge, but they may not be able to make constructive changes. We need to ask which person has demonstrated some leadership and capacity to improve the system." She won 70% of votes and, with no Democrat opponent, she took up the role in 1975. She later frankly described her trial experience in a way that trial judges, I think, might understand. There are moments of great pathos in a courtroom, and there are moments of levity, and there are moments of boredom. In 1978, she was encouraged to run for Governor of Arizona, but she declined as she knew she did not have the numbers. The selected Republican candidate lost to Democrat Bruce Babbitt. In 1979, Governor Babbitt appointed Judge O'Connor to the Arizona State Court of Appeals. Some claimed her elevation was motivated by Babbitt's desire to remove the threat of a strong future Republican gubernatorial candidate. Governor Babbitt insisted he appointed the most qualified person, who also happened to be a woman. Shortly before her swearing in as an appeals court judge, the O'Connors, both considered excellent conversationalists, were invited on a houseboat vacation on Lake Powell with Supreme Court Chief Justice Warren Burger. Chief Justice Burger was impressed by Judge O'Connor's personal warmth and legal experience and began thinking about ways to involve her in national legal conferences. He later invited her to join the US delegation attending an Anglo-American legal conference in London. The 1980 Republican presidential candidate, Ronald Reagan, was fighting to remove the incumbent Democrat President Jimmy Carter. At its national convention, the Republican Party renounced its support for the proposed Equal Rights Amendment to the US Constitution to guarantee equal rights for women. It aligned itself with pro-life anti-abortion groups. Many women were unimpressed, and polling revealed declining female support for the Republican Party and its presidential candidate. An October 1980 poll found that Carter was leading Reagan among women voters, 38 to 31%. In response, Reagan promised that, if elected, he would appoint a woman to the Supreme Court. He was elected, and when Justice Potter Stewart announced his retirement in June 1981, the search for his replacement began. Unsurprisingly, Sandra Day O'Connor's name was on Reagan's list, and the White House sent representatives to Arizona to scout her. Attorney General Bill Smith, a former partner of Gibson, Dunn and Crutcher, the firm who in 1952 refused her a graduate job but offered her employment as a secretary, called to ask her to Washington to talk about a position. Addressing the firm's centennial celebration in 1990, she recalled, "I can remember as if it were yesterday when Bill Smith telephoned me on June 26, 1981, to ask if I could go to Washington, D.C. to talk about a position there. Knowing his former association with your firm, I immediately guessed he was planning to offer me a secretarial position." But would it be as Secretary of Labor or Secretary of Commerce? Events moved quickly. On 1 July, she met with President Reagan at the White House, where they discussed their shared love of ranch life. Recounting the meeting in an interview years later, she said she flew home not thinking she would be asked to serve and breathed a sigh of relief. But the President did not interview anyone else and instructed staff to complete the groundwork for the nomination. Judge O'Connor's name was strategically leaked to the press. 5 days later, President Reagan phoned and offered her the nomination as the 102nd Justice of the US Supreme Court and the first woman justice. She accepted, and on July 7, 1991, the President made the nomination public, stating, "She is truly a person for all seasons, possessing those unique qualities of temperament, fairness, intellectual capacity, and devotion to the public good, which have characterised the 101 brethren who have preceded her. I commend her to you, and I urge the Senate's swift bipartisan confirmation so that as soon as possible she may take her seat on the court and her place in history." Bipartisan goodwill flowed to Judge O'Connor, with national jubilation about the historic nomination of a woman. Democrat Senator Edward Kennedy said, "Every American can take pride in the President's commitment to select such a woman for this critical office." Barbara John, an African-American Democrat congresswoman from Texas, said, "The Supreme Court was the last bastion of the male, a stale, dark room that needed to be cracked open. I don't know the lady, but if she's a good lawyer and believes in the Constitution, she'll be all right." And of course, women's groups, not just in the US, but around the world, were elated. Some say life imitates art, and in the US, art includes Broadway and Hollywood. The Broadway play, The First Monday in October, starring Henry Ford and Jane Alexander, had opened in 1978. The plot revolved around the imaginary appointment of the first woman Supreme Court Justice, a conservative who clashed intellectually with an older Liberal justice, but over time they developed mutual admiration and respect. The play became a film in 1981 with Walter Matthau and Jill Clayburgh, both nominated for Golden Globe Awards. Although not due for release until February 1982, following Sandra Day O'Connor's nomination, the Canny producers brought forward its release to August 1981. Meanwhile, Judge O'Connor prepared for the confirmation hearings. She studied not only legal questions, but also senators' personal histories and interests so that she could reference her answers to their work in the area. She had experience in assisting Justice Rehnquist prepare for his confirmation hearings in 1971, and she had learnt the political skills to neutralise adversaries. One of the most controversial issues being litigated by the US Supreme Court at this time was abortion. In 1973, in Roe v. Wade, Justice Blackmun delivered the opinion of the court in which Chief Justice Burger and Justices Douglas, Brennan, Stewart, Marshall and Powell joined, with only Justices White and Rehnquist dissenting. The court held that the right to privacy under the 14th Amendment extended to a woman's decision to have an abortion. The right, however, needed to be balanced against two important state interests in regulation: protecting and preserving the health of pregnant women and protecting the potentiality of human life. To reconcile the two competing considerations, the court adopted a bright-line rule that left the decision as to abortion in the first trimester for the woman, but the closer the woman became to delivery, the more the state was permitted to regulate. During the confirmation hearings, she was repeatedly asked her views on abortion. Pro-life senators raised that, as an Arizona senator, she had supported the repeal of a law decriminalising abortion. She agreed that she had supported the repeal of the law, which did not allow for a rape victim to undergo a prompt procedure to prevent pregnancy. She added that her knowledge of the issues had grown since, and she would no longer support the repeal of the law. When asked about her personal feelings, she said that she found abortion repugnant and something in which she would not engage. Socially conservative Reagan supporters wanted to know whether she would vote to overrule Roe v. Wade if given the opportunity. She rightly refused to answer. This could compromise her independence in deciding the issue in the future. She did, however, allay concerns about judicial activism, saying, "My experience as a state court judge and as a state legislator has given me a greater appreciation of the important role the states play in our federal system, and also a greater appreciation of the separate and distinct roles of the three branches of government at both the state and the federal levels. Those experiences have strengthened my view that the proper role of the judiciary is one of interpreting and applying the law, not making it." In contrast to more recent nominees, Judge O'Connor's confirmation hearings were gentle. The transcript of them was 420 pages over 3 days, whereas those for Justices Sonia Sotomayor and Elena Kagan, the last two justices appointed to the court, were over 4 days and covered 1,406 pages and 1,117 pages, respectively. Despite the concerns of the pro-life lobby, Judge O'Connor was unanimously confirmed 99-0. She would have received 100 affirmative votes, but one senator was out of town. By contrast, Justice Rehnquist was confirmed 68-26, Justice Sotomayor 68-31, and Justice Kagan 63-37. The 51-year-old Sandra Day O'Connor was sworn in as the 102nd Associate Justice of the US Supreme Court on 26 September 1981 by Chief Justice Burger. Later, when posing with Pwotzik for photos outside the court, the Chief Justice joked in a way that was common at the time but now seems inappropriate, "You've never seen me with a better-looking justice, have you?" Justice O'Connor was expected to be conservative in her judicial opinions, but it was unknown whether, and if so to what extent, they would be influenced by her views on women's rights and her personal experiences of discrimination. Her opinions came to bear out the views she expressed in her confirmation hearings, that she believed in the incremental development of the law, not radical change. Over time, her opinions also came to reflect her astute understanding of how far, at any given point, she could push both societal acceptance and enough judges to achieve a majority. This approach suited her coalition-building style, learnt as an Arizona politician. Much is known about the deliberations of the Supreme Court justices at this time because Justice Thurgood Marshall, the first African American to be appointed to the court, who served from 1967 to 1991, left his revealing personal and judicial papers to the Library of Congress. On his death in 1993, they were controversially made public. Following oral argument, the judges routinely held a conference after the hearing to discuss their views as to the outcome of the case, with the most senior judge speaking first and the most junior last. In Justice O'Connor's early years on the court, this allowed her, as the junior judge, to sense the majority opinion, with which she usually aligned herself, mostly joining or concurring with Justice Rehnquist. When a Supreme Court judge joins in a circulated opinion of another justice, or part of it, the justice agrees with the reasoning. When a justice writes a concurring or partially concurring opinion, the justice agrees with the outcome in the circulated opinion, or part of it, but either expresses different reasons or additional reasons. As Justice O'Connor's seniority, experience and confidence increased, she would often remain uncommitted at the post-hearing conference, so that in close cases, both sides would vie for her crucial vote. She worked the court like a seasoned politician, using her opinion as a strategic tool in a case-by-case approach. She often diluted a joint opinion of its binding authority by writing a separate concurrence. On many issues, for example abortion, she used her opinions and concurrences over successive cases to move the court to the centre and to adopt her reasoning. In 1993, just 2 years after Justice O'Connor joined the court, it considered the issues relating to abortion and the correctness of Roe v. Wade in City of Akron v. Akron Centre for Reproductive Health. Ohio had enacted laws that required all abortions after the end of the first trimester to be performed in hospitals, prohibited unmarried minors under 15 from having an abortion without parental or judicial consent, mandated that an abortion could not be performed until 24 hours after the patient signed a consent form, compelled doctors to obtain informed consent from patients before abortion could be performed, and created criminal sanctions against doctors who failed to dispose of fetuses in a humane way. Justice Powell delivered the majority of the opinion of the court, in which Chief Justice Burger and Justices Brennan, Marshall, Blackman and Stevens joined, striking down the laws and applying the test from Roe v. Wade. Justice O'Connor, with whom Justices White and Rehnquist joined, dissented. She considered the majority Roe v. Wade test was too focused on the trimester stages of pregnancy. In her view, the point at which the fetus became viable was a sliding scale. Stringent delineation between the trimesters was artificial. As medical science improved, the fetus could become viable within the first trimester. She considered the focus instead should be on whether the impugned laws were unduly burdensome. She considered states could regulate abortion as long as they did not impose an undue burden on a woman's decision to terminate the pregnancy. She would have upheld all the impugned Ohio laws, as in her view, none were unduly burdensome. The undue burden test in Akron is an excellent example of Justice O'Connor's preference for a contextual, fact-driven, case-by-case approach, recognising medical developments and social change over what she apprehended as the less flexible legal doctrine of the strict trimester-based bright line rule in Roe v. Wade. Following the death of Chief Justice Burger, the retirement of Justice Powell, Justice Rehnquist's elevation to Chief Justice, and the appointment of Justice Scalia in 1986, the court was seen as having 4 staunch conservatives, Justices Rehnquist, Scalia, Kennedy and White, and 4 staunch liberals, Justices Brennan, Blackman, Marshall and Stevens. Justice O'Connor used her swing vote to such great effect in these years that the US Supreme Court was known as the O'Connor Court. In October 1988, Justice O'Connor was diagnosed with breast cancer and required an immediate mastectomy, another obstacle to be overcome. This courageous and resilient rancher left hospital after 5 days, and 5 days after that was back hearing oral arguments. She scheduled chemotherapy for Fridays, so she had the weekends to recover, and did not miss a day in court. She found work therapeutic. Her treatment was successful, and she allowed her story as a breast cancer survivor to be publicised to assist other women battling the disease. The following year, 6 years after Akron, in Webster v. Reproductive Health Services, the court considered the lawfulness of a Missouri statute that required all state laws to be interpreted to provide unborn children with equal rights to other persons, subject to the limits imposed by the Constitution, prohibited government doctors from performing an abortion if they believed the fetus was viable, prohibited the use of state resources to perform or assist abortions unless necessary to save the mother's life, and prohibited government from encouraging or counselling a woman to have an abortion unless it was necessary to save her life. Chief Justice Rehnquist considered there was no affirmative obligation on states to fund non-therapeutic abortions. Viability testing after 20 weeks was constitutional, significantly narrowing the application of Roe v. Wade. Abortion restrictions were allowed if they reasonably further the state's interest in protecting potential human life. Justices Blackmun, Brennan and Marshall dissented in part, not wishing to narrow the application of Roe v. Wade. At conference, Justice O'Connor initially voted with the Conservative bloc. Justices White, Scalia and the newly appointed Kennedy informed Rehnquist that they would join in his opinion. But Justice O'Connor, uncharacteristically, did not immediately respond. Over a month later, she issued her concurrence, agreeing with the Chief Justice in the result, but not accepting his rejection of Roe v. Wade. Applying the test she articulated in Akron, she held that a regulation imposed on lawful abortion, pre-viability, is not unconstitutional unless it unduly burdens the right to seek an abortion. Further, as the constitutional validity of the Missouri laws did not turn on the constitutional validity of Roe, there is no necessity to accept the state's invitation to re-examine the constitutional validity of Roe and Wade. When the constitutional invalidity of a state's abortion statute actually turns on the constitutional validity of Roe v. Wade, there will be time enough to re-examine Roe and to do so carefully. In this way, she deprived Chief Justice Rehnquist of a majority opinion to overturn Roe v. Wade. Justice Scalia was furious and then wrote his own concurrence with the Chief Justice's opinion, making a stinging attack on Justice O'Connor's refusal to revisit Roe v. Wade, which, he was adamant, should be overturned. Justice Blackmun, the author of the majority opinion in Roe v. Wade almost 2 decades earlier, in his partial dissent in which Justices Brennan and Marshall joined, said, "Today, Roe v. Wade and the fundamental constitutional right of women to decide whether to terminate a pregnancy survive, but are not secure. I fear for the future. I fear for the liberty and equality of the millions of women who have lived and come of age in the 16 years since Roe was decided. I fear for the integrity of and public esteem for this court." Webster firmly placed the fate of Roe v. Wade in the balance, and Justice O'Connor was poised to decide its future. That opportunity arose in 1992 in Planned Parenthood of southeastern Pennsylvania v. Casey. The Federal Court of Appeals, relying on Justice O'Connor's opinion in Webster, had ruled that Roe v. Wade no longer commanded a majority of the Supreme Court. Utilising Justice O'Connor's undue burden test, they upheld Pennsylvanian laws which required the passage of 24 hours between the doctor giving exhaustive information about the abortion process and obtaining informed consent and any abortion, required the informed consent of at least one parent if a minor was having an abortion, with a judicial bypass procedure as an alternative, required reporting by abortion facilities, and excused non-compliance with these requirements in medical emergencies. The Federal Court of Appeals did not uphold a provision in the laws that required women to alert their husband of their intention to have an abortion. Until now, Justice O'Connor had yet to find a law that regulated abortion and which amounted, in her opinion, to an undue burden under her test. During oral argument, she made clear that she was uncomfortable with the spousal notification provision. At the post-hearing conference, the clear majority of justices voted to uphold the laws, except for the spousal notification provision, but it remained to be seen whether Chief Justice Rehnquist would have a majority to overturn the reasoning in Roe v. Wade. Following the conference, Justice Souter, who was appointed by President George W. Bush but came to be considered a Liberal judge, approached Justices O'Connor and Kennedy, both Reagan appointees but seen as moderates. Justice Souter expressed his preference for upholding the central principle of Roe v. Wade, that the 14th Amendment implies and protects a woman's fundamental but not unlimited right to control the outcomes of her reproductive actions. He recognised that advances in maternal health and neonatal care meant that the rigid trimester framework of Roe v. Wade should be replaced by Justice O'Connor's undue burden test, as she articulated almost a decade earlier in Akron. The three justices each wrote a section of a jointly drafted opinion which began, "Liberty finds no refuge in a jurisprudence of doubt. Yet 19 years after our holding that the Constitution protects a woman's right to terminate her pregnancy in its early stages, Roe v. Wade, that definition of liberty, is still questioned." The end result was that the court, by a 5-4 majority, Justices Stephen, Blackmun, O'Connor, Kennedy and Souter, with Chief Justice Rehnquist and Justices White, Thomas and Scalia dissenting, upheld Roe v. Wade's recognition of a woman's right to choose to have an abortion before fetal viability, confirmed the right of the state to restrict abortions after viability, with exceptions for pregnancies endangering a woman's life or health, and affirmed that, from the start of the pregnancy, the state has legitimate interests in protecting both the woman's health and the life of a fetus that may become a child. Ultimately, all the impugned Pennsylvanian provisions, except for the spousal notification provision, were upheld by a differently constituted majority. But what this all meant was that with the critical 5 votes, including Sandra Day O'Connor's, Roe v. Wade was safe. Announcing the opinion in court, Justice O'Connor, consistent with her answers during the confirmation hearings, said, "Some of us as individuals find abortion offensive to our most basic principles or morality, but that cannot control our decision. Our obligation is to define the liberty of all, not to mandate our own moral code." More than 25 years later, Justice O'Connor's undue burden test remains the standard against which US state laws regulating abortion must be measured. Earlier this year, in Whole Woman's Health v. Hellerstedt, the undue burden test, engineered over time by Justice O'Connor, was once again applied. When Ruth Bader Ginsburg joined the court in 1993, Justice O'Connor publicly expressed her delight and also her relief from the media clamour of Whatzik. The Christian Rancher Republican and the Jewish Brooklyn Democrat had very different backgrounds and jurisprudential approaches, but each was strengthened by the other's presence on the court, conscious of their shared heavy responsibilities as female role models committed to gender equality. Bush v. Gore was another of the many cases where Justice O'Connor's decision was critical to the outcome, here ending challenges to the Florida voting results in the 2000 presidential election and effectively securing George W. Bush's success. The court was split 5-4, with Justice O'Connor's vote again crucial. Some later argued she should have recused herself, as her husband John, suffering from early onset Alzheimer's, said at a public function shortly before the court heard the case that if Gore won the election, Sandra could not retire to Arizona for at least another 4 years. 12 years later, with hindsight, she was widely reported as stating that Bush v. Gore was a case in which the US Supreme Court should not have become involved. In her later years on the court, Justice O'Connor voted more often with the Liberal judges, supporting affirmative action, striking down the death penalty insofar as it applied to the mentally retarded, and declaring criminal sodomy laws unconstitutional. In terms of life imitating art, perhaps she was turning a little into Jill Clayburgh's character in the Hollywood film The First Monday in October. In 2005, she became the first woman justice to preside in the US Supreme Court when Chief Justice Rehnquist was ill and battling cancer. She announced her retirement on 19 July 2005 to take effect on the appointment of her successor. She intended to spend more time with John, whose Alzheimer's had progressively worsened. President George W. Bush announced US Court of Appeals for the District of Columbia Circuit Judge John Glover Roberts Jr. as her successor. But when her dear friend and colleague Chief Justice Rehnquist died on 3 September 2005, the President nominated Judge Roberts as Chief Justice. Initially, White House counsel Harriet Miers was to replace Justice O'Connor. After prolonged controversy, however, President Bush withdrew Ms. Miers' nomination and instead nominated Judge Samuel Alito from the US Court of Appeals Third Circuit, who was confirmed and sworn in on January 31, 2006, and Sandra Day O'Connor left the US Supreme Court. Since leaving the court, she has remained an active contributor to public life. She has become a champion of fostering public appreciation of the principle of judicial independence, arguing against the notion of elected judges. In 2012, she testified before the Senate Judiciary Committee on the importance of civil education. She helped establish iCivics, a website initially focused on the judicial branch of government, but later expanded to include the legislature and the executive. The iCivics website engages at least 4 million students and 110,000 teachers through online games such as Supreme Decision, where the player is a Supreme Court justice who must cast the deciding vote in an important case, and Do I Have a Right, where the player is a constitutional lawyer taking clients' instructions, determining their rights and running their cases. I met Sandra Day O'Connor not long after her retirement when she visited Brisbane on 13 September 2006. She travelled to Australia to speak at an Australian Institute of Judicial Administration, AIJA, conference in Adelaide. Justice John Byrne was then the president of the AIJA and hosted her whirlwind visit. She travelled to Brisbane, she confessed to me, primarily to visit Australia Zoo. She was a great fan of Steve Irwin, who tragically had died only a few weeks earlier. I heard Fwatzik speak warmly and encouragingly to a group of awestruck Queensland University of Technology law students about judicial independence and the important role of lawyers in protecting it. When I met her again later that night at a function at Government House, hosted by then Queensland Governor Quentin Bryce AC, like a groupie, I had her sign my copy of her book, The Majesty of the Law. At 76, her intellect remained sharp and she was still an excellent conversationalist, charming, unassuming and smartly groomed, wearing bright-coloured stiletto shoes. I think she was competing with the governor. I'm pretty confident she was also wearing her bra and her wedding ring. She seemed genuinely pleased and a little surprised when I spoke of her influence on Australian women lawyers of my generation as an exemplar role model. We chatted of the challenges of working in demanding careers as first women and the more general challenges for working women raising families, especially in the teenage years. You may not be surprised that her solution to the terrible teens was ranch holidays. She also spoke frankly of her profound sadness that John's illness had deteriorated so far that she could no longer care for him and that he was now in a facility. I was interested to hear at an International Women Judges Conference some years later that John was initially very unhappy in the facility, but later fell head over heels in love with a woman patient. I apprehend that this is not uncommon behaviour for sufferers of Alzheimer's. After 55 years of marriage, the courageous and compassionate Sandra Day O'Connor, with the support of her sons, gave John her blessing. She was relieved to see him no longer anxious and depressed, but happy as a schoolboy. She allowed the story to become public, to assist other Alzheimer patients and their families, and to inform the public of the effect the disease can have on marriage and carers. In 2008, she testified before the Senate Special Committee on Ageing and called for a national strategy against Alzheimer's to find a breakthrough by 2020. John J. O'Connor III died on 11 November 2009. More sadness followed in May this year when her younger sister Anne, who also became an Arizona senator, was killed in a dreadful two-car crash with the driver of the other vehicle charged with manslaughter. Despite those sadnesses, Sandra Day O'Connor has continued to live a rich and full post-Supreme Court life, both in the law and academia. For many years, she has sat regularly on federal appellate courts when an additional member was needed to fill a vacancy. She took over in 2006 from Henry Kissinger as the Chancellor of the venerable and renowned Virginian University, the College of William and Mary, and served in that role until 2012. I do not always agree with President Reagan's views, but his description of Sandra Day O'Connor in announcing her nomination was apt. She is truly a person for all seasons, possessing those unique qualities of temperament, fairness, intellectual capacity and devotion to the public good. To those qualities I would add courage and resilience learnt on the ranch from the cowboys, allowing her to overcome obstacles others would find unsurmountable. And like her mother, Ada May, she shared compassion and moments of pleasure with all those whose lives she touched. Sandra Day O'Connor has received countless well-deserved honours, culminating in President Obama's 2009 Medal of Freedom, the highest civilian honour in the United States. But I suspect her favourite accolade was her induction into the National Cowgirl Museum and Hall of Fame as Cowgirl Honoree. Even Harry Day would have approved. Thank you.
It's my pleasure to move the vote of thanks for the lecture. We have been treated to an illuminating and educational lecture about Sandra Day O'Connor, which educated us not only about her legal and judicial career, but about her personal life whilst a lawyer, a judge, afterwards and before. It is remarkable to reflect how much we have learned, or at least I have learned, in the 50 minutes that was occupied by the lecture. It was characteristically succinct and thorough at the same time. May I ask you once again to thank our speaker. And it's my pleasure to pass over the usual gift to our speaker. Just two final things I should mention. First, and importantly, you may wish to mark your diaries for the next lecture in the series, which will be given by the Honourable Richard Chesterman, AO, RFD QC, who I'm pleased to note is in the audience tonight, on legal history of Queensland, the Supreme Court Fire of 1968. And lastly, and not quite as importantly, but still importantly, you are all invited to enjoy refreshments in the foyer now. Thank you.